So today we're going to talk about common and avoidable mistakes with your fee agreement. Now, why am I even bringing up this topic and doing a video on it? Well, I do fee arbitrations for our local county bar. And as a result, I get to see other people's contracts and I get to see the common mistakes that they make that are completely avoidable, but ultimately causes problems for them. And so I'm going to go over a number of the very common things that you need to be clear about in your contract. Now, the first thing that I want to say is in probably 99% of the cases, the fee agreement is the very first piece of legal work that your client has seen from you, right? Think about that. This is the first document that you're going to give them, a legal document, right? Because once it's signed, its contract is binding, that they're going to see from you. How does it look? Does it look sloppy? Does it look like you threw it together with a crayon? Or does it look super professional, right? You should be proud of your fee agreement. Your fee agreement shouldn't have secrets. It should be like, anything that's important should be right there and you should go over with it because fee agreements are really important. And I will tell you that if I have to get involved as an arbiter for a fee agreement, 9 times out of 10, the bar's involved as well. And so you want to be very, very careful about making sure that your fee agreement is valid and enforceable. All right. So what are common mistakes that I see? Bar rules, right? Does your contract comply with the bar rules? Now, in California, in particular, there are 2 really important rules involving flat rates. Rule 1.5 and Rule 1.15, I believe, are kind of the key ones. You cannot take a flat rate and put it into your operating account until you have a waiver from your client. And what that means is that not next week, not next month, not tomorrow, but if the money comes in, it can't go into your operating account until you have that waiver, all right? And it has to be clearly stated in your contract. Now, again, this isn't rocket science, but if you're doing any kind of flat rate, you need to make sure that you're complying with the rules. You need to comply with all the rules. I've seen people do, $10,000 cases with no contracts. What's up with that? In California, anyway, the bar rules, if it's over $1,000, there's got to be a written contract. And it just makes sense. You're lawyers, for goodness sakes. How are you going to enforce an unwritten contract? So your fee agreement is super important. Make sure it complies with the bar rules. If you're not sure, check, find out. You're a lawyer. Research this. Make sure that in your jurisdiction, your bar rules are compliant. Maybe if you have some questions, go to a friend and say, hey, can I look at your contract? Can I see what maybe you have that I don't have? All right. Second thing, the terms are clear. What are the terms of your agreement? What are you going to do and what do they have to do? The boilerplate language that most people use is fine. I'm not suggesting that, you need to change every word, but when it comes down to what you're actually going to do, the line or 2 in your contract that says, this is what we are going to do. Be sure that you're clear. All right. We're going to represent you up to this stage. We're going to if you're a family law, we're going to represent you up to arbitration or mediation, right? And if it doesn't resolve there, then we're going to have to reassess. All right, are we going to go to trial? What are we going to do? In a criminal case, we're going to represent you up to the preliminary hearing, or we're going to represent you up to trial. Just understand that, you got to get a judge to let you out of the case. And I had a judge one time, the client bounced me check. $50,000 worth of checks he bounced. And I went to the judge and said, Judge, I need out. And the judge said no. And I had to do the trial. So, but be clear on your terms. What is it that you're agreeing to do? How far do you go with the case? What are your parameters? And I don't think it makes any difference whether it's personal injury, bankruptcy, family law, criminal law, immigration, whatever. What are you going to do for that price? All right, be super clear as you can be. What's the purpose of a contract? To tell you what to do when things go wrong. When things go right, you don't need the contract, right? Everybody's agreed. It's all good. Everybody's happy. But when things go wrong, what happens? And you need that to be super clear, that the terms of your contract are really, really clear. You need to have an hourly rate in your contract. Now, I don't care if you do flat rate, contingency, subscription, it doesn't matter. If there is a dispute, what is the value of your time? Some lawyers say, it's $250. Other lawyers say it's $1,000. I charge $600. I've had clients, or people that I've seen, charge $400. Whatever you think the value is, we can determine that whether that's reasonable. But if a client agrees to that hourly rate, then by definition is probably agreeable. What happens if for whatever reason you can't fulfill the terms of the agreement? All right. So you're doing a criminal case, you agree for $10,000 to take it up to the preliminary hearing, and for whatever reason you cannot do that preliminary hearing. You get sick, there's a problem. They fire you, whatever. You did not fulfill the terms of the agreement. Well, how do we determine how much money you are entitled to under quantum merit? You are entitled to being paid for the work that you've done. I need to know, and any arbiter needs to know, what is your hourly rate so that we can say, okay, well, this is what was agreed on, so now we can start doing the math. Have your hourly rate in there as a contingency. If things go wrong, this is what we charge. All right, your way out. How do you get out of a case? In my opinion, you need to have that in your contract. We take it up to the preliminary hearing, or in family law, we might take it up to the mediation, or bankruptcy, we take it up to this stage, and if we get tossed out on our ear, we don't go back. What stage? If you have a trial contract, if a contract for doing a trial, what happens if it hangs? What happens is there's a mistrial, and you go through the entire thing, and now you still have no verdict. What are you going to do? Is that your way out? How do you get out? It's important that you have a way out, because you might need to get out for a whole host of reasons. And, you don't want to be trapped in a contract with somebody. I mean, once you enter into a contract, in my opinion, you got to do the honorable thing. You've got to honor the contract. If it was a bad contract, that's on you. You're the lawyer. You wrote the damn thing. So always have a way out. Know what your way out is. So if things go sideways on you, you have the ability to do that. All right. Payment plans. Right? Maybe you do payment plans. We did payment plans, especially for things like DUIs, right? Our deal was, at that time, we were charging $5,000. You had to have 50% up front, so you had to give us a check or a credit card for $2,500, and then we would do a payment plan for the last $2,500. But you need to be very specific. I mean, this is how much you're going to pay, and this is the date. This is how much you're going to pay. This is the date. This is how much you're going to pay until it is all paid off. Are you going to charge interest? What are you? Maybe you don't charge any interest unless they're late with payments. And then, that gives you a little bit of a hammer to get them back on the payment schedule, and it gives you a way to negotiate. If you're doing payment plans, you need to have somebody collecting, right? Following up with it, making sure that the payments are being done. And they need to have super clear guidance. And if there's a payment plan in the contract that they have signed, then that becomes super clear. All right. So payment plans. All right, here's an avoidable mistake. So what are common mistakes? They don't follow the bar rules, the terms aren't clear, they don't have an hourly rate, they don't give themselves a way out, there's no payment plan. Here's the one that shocked me, actually. In the last two arbitrations that I've done, this is what occurred. Make sure it's signed. The last two I did, the contracts were not signed. The contract is not valid if it is not signed. Let me just say that again. One attorney goes to the jail with the contract, says to the client, I want you to, I need you to sign the contract for me to represent you. The client said, no, I'm not going to sign it. What'd the attorney do? He continued to represent him, right? And now, surprisingly, he got reported to the bar. He's getting, we had to do an arbitration. I don't know if there's going to be a lawsuit about it, whatever, but the answer is if you won't sign the contract, I cannot represent you. It's unethical for me to continue to represent you. The bar rules require anything, at least in California, anything over $1,000, you got to have a signed contract. And you're a lawyer. To work without a contract is, I don't know. To me, it's a avoidable mistake. That is a fumble on the 1 yard line. All right. Not only does it need to be signed by the client, all right, absolutely need to be signed by the client, but also any third party payer, right? If somebody other than the client is paying, so mom, dad, brother, sister, wife, rich uncle, I guess GoFundMe maybe would be all right. I don't know. But if there's a person, you got to have them sign it. And in California, you got to have a waiver saying, look, I represent the client, not the payer. And I'll give you the example that I give when I talk to clients about this issue, because I always insist on having this done. This is a totally true story. Had a dad come in with his kid, Junior. Junior had gotten in trouble. He's being prosecuted in juvenile hall, right? Dad goes ahead and hires me, and then he takes me aside and he says to me, look, I think it would do Junior some good to spend some time in juvenile hall. And as a dad, I probably didn't disagree. But when I go talk to Junior, he didn't want anything to do with that, right? He didn't want to spend any time in juvenile hall. So what is my loyalty? My loyalty has to be to the client, not to dad, right? Not to the wife, not to the uncle, not to the mother, not to the father. I mean, a lot of times what they want is different than what your client wants, or is different than what you should be doing. So you need to not only have a waiver, but you need to have that signed that shows that you've had this conversation with these people. All right. You're not going to like this one. Track time. And especially for people who are doing flat rate stuff. I mean, I have people tell me, well, I don't track time because I do flat rate. And so somehow that relieves them of the obligation to do that. I'm going to tell you as an arbiter as a general rule, that is a huge mistake. You need to know how much time you spend. I do a whole nother video on data that you should track and why you should be tracking all of this. But from a fee agreement perspective, if for some reason you are not able to complete the terms of the agreement, you get fired, you quit, you get sick, for whatever reason, how do I know what fee you earned, right? It's going to be a combination of your hourly rate, right, and how much time you spent, right? These are the two things that are going to give me a number. You spent 10 hours at $200 an hour, all right? So that's $2,000. You spend 20 hours at $400 an hour, whatever it is. It's just get the calculator out and do the math, right? If you did a flat rate and you did not complete the terms for whatever reason, how do I figure out the value, right? What if for whatever reason you didn't get the contract signed or whatever? It's not a valid contract. I will tell you, probably over half the time when I do an arbitration, I find that the contract's not valid. Sometimes because it's not signed, but other times because it just doesn't comply with any of the rules, right? So if it doesn't comply with the rules and it gets ruled invalid, then under quantum merit, how do I figure out how to value that time. You got to track your time. There's a whole host of reasons. Failure to do that, I think, is a fumble on the 1 yard line, and it's a completely avoidable mistake. And with the software that exists nowadays, it's as easy as could possibly be. There's nothing to it. So, and it doesn't take any time. To me, it's just an inexcusable mistake. And then the last thing is you gotta have accounting, right? Your client, under bar rules, is entitled to a full accounting of the work that you do. Doesn't matter if it's flat rate. Doesn't matter if it's contingency. I mean, I guess you could put in your contract that they're not entitled to that, but I don't know that would pass muster, but they are entitled to it. You are doing work. They are paying you money. However, whether it's flat rate, hourly rate, subscription, contingency, it doesn't matter. What work are you doing on them? The reason that they came to you as a lawyer, right, is they got a problem, and you're supposed to be fixing it for them, or at least trying to, doing your very best, right? I realize there's problems that we can never fix, but what are you actually doing? I recently had an arbitration where the attorney did not go out and see the client over the 109 days that he represented him. 109 days. And he was too busy. Now, if you're too busy to go see your client over 3 months, then you should not be taking that case. Simple as that. So you need to have an accounting. And I'm just telling you that as an arbiter, I want to see that accounting, and your client is entitled to it, and you can get yourself in trouble with the bar if you don't provide an accounting. So, common avoidable mistakes. Realize, one, this is the first document that they're going to see that shows your skills as a lawyer. All right, so let's make it right. Make sure it complies with the bar rules. Make sure that the terms are clear. Don't just boilerplate it. Make the terms really clear. What are you agreeing to do? Have an hourly rate in there. Have a way out. If you have a payment plan, have that be very specific. Don't just leave that to, whenever you get around to it. Make sure it's signed. All right. Make sure you have a signed copy of it. Make sure that the third party, if there's a third party payer, that they're signing as well. Track your time and be prepared to have a full accounting. If you use good software, my case, Clio, Practice Panther, there's a ton of these out there, right? All you'd have to do is click a button, and you would have the time, and you would have a full accounting of what's going on. All right, everybody. I hope this is helpful.